And now, days after the Supreme Court of Kenya released its full judgment of the presidential election petition of 2022, the Azimio la Umoja One Kenya coalition has once again criticized the same judgment and asked Kenyans to consider whether or not the Supreme Court is serving the purposes for which it was established. The coalition also says the court has failed to deliver on its most critical role. Clement Masombo has more.
Just 3 days after the Supreme Court of Kenya released a 130-page full judgment on the presidential petition that upheld the election of President William Ruto's win, the Azimio la Umoja coalition has issued a 13-page statement criticizing the same judgment. In a statement signed by Professor Makau Mutua and lawyer Paul Mwangi, the Azimio team highlighted 6 areas where they believe the judges made mistakes. The Azimio la Umoja in the statement said, and I quote, "We argue that on all major planks of our petition's argument, the court failed to satisfy the basic requirements of a fair trial. The language directed at the petitioners was sophomoric and unbecoming of the highest court in the land." End of quote. On the question of whether the technology deployed by the IEBC met the standards of integrity, verifiability, security and transparency to guarantee accurate and verifiable results, the court ruled that scrutiny report prepared by the registrar of the court did not reveal any security breaches of IEBC servers. On whether there was interference with uploading and transmission of Form 34A from the polling station to the IEBC public portal, the petitioner had argued that the image of Form 34A captured by the KIMS kit was in JPEG format but ended up on the IEBC public portal as a PDF document, and as such, the petitioner asked the court to seek an explanation from the commission on why the image of Form 34A was converted from JPEG format to PDF format. The court, however, ruled, and I quote, "Regarding the allegation that the integrity of the public portal was compromised, this was disproved by the evidence of consistent attributes such as unique timestamps on the forms." On the question of whether there was a difference between Forms 34A uploaded on the IEBC public portal and Forms 34A received at the National Tallying Center and Forms 34A issued to agents at the polling station, the petitioners presented to the court copies of documents it had received and demonstrated how different they were from the forms on the portal. They also presented 2 forensic analysis reports from the document examiners that showed how the alternative forms were being generated. The court, however, dismissed the petitioners, saying the purported evidence of Celestino Pio and Arnold Oginga sworn in their respective affidavits were not only inadmissible but also unacceptable. On the issue of whether IEBC carried out verification tallying and declaration in accordance with Article 88(3)(c, the petitioner had argued that the commission's chairperson, Wafula Chebukati, did not involve all the commissioners in the process of verification of the results before declaration of the winner. On this, the Supreme Court agreed with the petitioner. It, however, proceeded to say in the judgment it could not nullify an election based on the last-minute boardroom rupture between the chairperson of the commission and some of its members, and as a result, the bench dismissed the petitioner. The Azimio la Umoja, in its conclusion, says the Supreme Court has failed to deliver on some of its most critical mandate and that Kenyans have a right to ask whether it should continue to exist. They further say Kenyans need to consider whether the Supreme Court is serving the purposes for which it was established. Clement Masombo, KTN News.
Now, key players in the climate change campaigns in Africa are calling for continental cooperation to